Welcome to the MK True Crime Show. I'm Ashley Merchant, a criminal defense attorney from Atlanta, Georgia. Today, I am joined by my co-host, Dave Ehrenberg. He is a former state attorney for Palm Beach County, Florida, and managing partner at Dave Ehrenberg Law. Hey, Dave.
Hello, Ashley. Let's go over what we have on the docket today. Carmelo Anthony. Yeah, it's blowing up all over the internet. He was found guilty of murder and sentenced to 35 years in prison for the stabbing death of 17-year-old Austin Metcalf at a Texas track meet last year. We'll break down the verdict, the sentence, and what surprised us about the high-tension trial.
And prominent Florida real estate broker George Pino is on trial this week for vessel homicide and manslaughter. We'll discuss the details of the boat crash that killed one of his daughter's friends and permanently injured another, and what to expect as the trial picks up.
Later, Cody Thomas, field reporter for Court TV, joins us to share his experience covering the Carmelo Anthony trial. You won't want to miss that. But first, let's talk about the verdict, Ashley.
Oh my gosh, let's talk about it. This was just crazy. I mean, watching everything and watching all the people, especially the people, to me, Dave, that didn't really know a lot about what's actually going on in the courtroom. So I'm glad we have this chance to kind of break it down. And I actually reached out to people on social media and said, send me questions. I want to explain it. Dave wants to explain it. We want to kind of get into it because there's so many questions here. And I think people can't really get reliable information about what went on in that jury room and what went on in that courtroom. And I know we're going to have our guest coming up in a few minutes that's actually from the courtroom. You know, he was physically there, so he can answer a lot of our questions. But you and I are going to get to go through some of the legal process as to how this case sort of unraveled.
Yeah, I'm excited to go over it, even though the case is tragic. And even we talk about Carmelo Anthony's mother taking the stand during the sentencing. And, you just see that there were multiple victims here. But at least Carmelo Anthony gets to leave prison one day for his sake. He's not going to lose his life over it like Austin Metcalf did. And Carmelo Anthony's mother, she gets to have her son live another day, not like the mother of Austin Metcalf or his twin brother have to deal with the permanent passing of their loved one. And it was so unnecessary that this whole thing happened. And, I know that you're 17 years old and your brain is not stopping to develop. It hasn't fully developed until you're like 25, 26.
Right.
But come on, everyone knows that you don't bring a big knife to a track meet. And everyone knows you don't break out the knife after someone just pushes you and stabs them to death. You just know, even at the age of 17, not to do that.
Right, you do. And most of the questions that I've seen, there's kind of two categories of questions. A lot of folks want to know what's going to happen with the appeal and, what are the grounds for appeals and stuff. But most of the questions I've had is actually about jury selection, which I thought was interesting and something that we can talk about. So a couple people, I'll just throw out some of the questions I've got and then let's talk about it for a minute. But a lot of folks have asked, what is Batson? So I want to talk about that because there's this legal term we throw around, Batson. And then a lot of people have also tried to understand how the jury ended up looking like it did. And so it wasn't an all-white jury, but it did not have anybody who identified as African American on it. So it's had some people who identified it, different races, different ethnic groups, but nobody that really identified outright as a Black person, a Black male or a Black female. So a lot of folks were really upset about that. So I kind of just want to walk our viewers through how a jury is actually selected so that they understand how we end up with the juries we get, because I think there's been a lot of outrage about that. So I don't know if you want to start with Batson, what Batson is.
Yeah.
I think as the state, you probably had people like me, jumping up and down saying Batson more than ever. But, Batson, just for our viewers, Dave's going to explain it a little bit, but it's a case, all these cases, when we throw out these names, Miranda, there's a person named Miranda. Batson, there's a person named Batson. So the cases are actually named after defendants. And I think that's always fun because you're always curious, what happened? How did that case end up in the Supreme Court? But Batson is essentially what talks about juries and what the makeup is, the racial makeup of juries and how we pick jurors.
Yeah, it comes from 1986. It's a U.S. Supreme Court case. It's Batson versus Kentucky. And the court ruled that discriminatory exclusions of jurors violate the Equal Protection Clause of the 14th Amendment. And so you have these things called Batson challenges, and defense lawyers love it because when prosecutors strike jurors that the defense doesn't like, and by the way, it works both ways, but still, defense lawyers like to use it. So in a prosecutor, like in a case like this, if a juror is struck for any reason, and in jury selection, you get what's called peremptory challenges, which means that you could strike a juror for any reason as long as it's not a bad reason. And that's where Batson comes in. You have a limited number of these. So you have unlimited for-cause strike. So if a juror says, I can't be unbiased, I've made my mind up, struck, that's a for-cause strike. But what if you just think this juror's not going to be with us? I just have that gut feeling, strike. And because of Batson, though, the other side could say, Your Honor, they're striking this juror because he's black. That you're trying to remove the black jurors from the jury, and that would be illegal, because although you can remove a juror for any reason using your limited number of peremptory strikes, you can't strike them for a bad reason, like race. And so what you have to do is the party making the objection has to show that there's an inference here that the opposing party, the prosecutor here, used the challenge to exclude a juror based on race. And then if the court finds that a prima facie case is made, the burden shifts to the party who made the strike, the prosecutor, to provide a race-neutral reason. So Your Honor, and I've had this, where I had a black defendant and I struck a black juror. It was an felony animal cruelty case. And the defense said, Your Honor, that's illegal under Batson. And I said, no. I'm striking this juror because when I asked this juror about his feelings towards dogs, he said, I don't have any dogs. I don't care about dogs. That's my reason. And the judge agreed, and he was struck.
Right. And that's a good reason. That is a good reason. And, I think it's interesting going into cases. One of the things that we always do as defense lawyers is we try to identify the type of jurors that we want. And sometimes that has race to do with it. Maybe in this case, they wanted certain races, but more often than not, it's a different type of juror. And I just want to kind of explain that to everyone. One of the questions I got was they had heard, and I don't even know if this is true or not, they'd heard there were 3 black females that were struck from the jury. Okay. So what if, and I think the outrage was, well, why were there 3 black females struck? What if all of those 3 black females had lost a son to a knife? That could happen. And so there's a lot of time that you see somebody that looks like the juror that you want, but maybe they've had a life experience that you don't want. There's also, we strike a lot of people if they say that they can't sit in judgment. I'm sure, Dave, when you were state attorney, you probably struck those people a little more than I would like to strike them. But we oftentimes have highly, highly religious people who are on the jurors, right, on the panel, and they say, I can't sit in judgment of someone else. I don't believe in that. And so we have to strike those people. No matter what color they are, we have to strike them. At least the state does. And I don't usually object to that because, that's a fair reason to strike. But so it's not so simple, I think, with jury selection. That's one of the reasons I wanted to talk about it, because I know a lot of people feel very angry about how this jury looked. And I understand that, because as soon as I saw the jury, I thought, couldn't you have done a better job with this jury, just to make people feel better about the system. But we don't know what happened. We don't know why those folks were struck. We don't know the different reasons. And it doesn't necessarily mean that the system's racist or it's rigged or something like that, because the process is a process of deselection. I had a lot of people ask, is that going to be something where we can win a new trial? They can win on appeal because he had an all-white jury. First of all, he didn't have an all-white jury. But second of all, right, it's very hard to prove Batson. I can tell you that I have won one appeal in 25 years on a Batson challenge, one. And I will never forget it. And your example earlier, Dave, kind of reminded me of it. I was trying to prove that the state, the prosecutor, had struck people because they were minorities. And one of the questions that he had said, his race neutral reason, was that he struck people who had gold teeth. And, immediately I was like, whoa, that sounds like the absolute most racist reason to strike people. Well, his answer was, well, I don't like jurors who like to stand out. And people who have gold teeth, they like to stand out. And the whole appeal was whether or not that was a race neutral reason or not. Luckily, the Court of Appeals ruled in my favor and said that's not a race neutral reason. And so I got a new trial for my client. But that's what this decision comes down to. It's such a fine decision as to whether or not, it makes sense. Maybe you don't like people who like to stand out. He said, I don't like people who have pink hair. I happen to have dyed my hair pink for that case, just for fun. But
You
that was
did?
I actually did. I will
You
put a
were in
picture up.
court as a lawyer
I
with
had
pink hair?
pink hair, hot pink hair, because he said that he did not like jurors who liked to stand out. And he said that's why he struck people who had gold teeth. And he also would have struck someone who had different colored hair, like pink hair, because he didn't like them to stand out. He didn't think they'd be good jurors. They weren't good citizens, weren't good jurors, stuff like that. And I was like, oh, well, by God, I can't get on gold teeth, but I can get pink hair, and I got pink hair. But that's what Batson is, So I just wanted to kind of explain that. Some of the other questions, Dave, we got were, obviously a lot of things about grounds for appeal. But one of the big ones I want to talk about, and I know we're going to talk about this with our guest, was why did Carmelo Anthony not take the stand? And I have a very big opinion on that because I went down some rabbit holes looking at some of the case pleadings. So I've got my opinion. I mean, were you surprised, Dave, about why he didn't take the stand?
I don't know if I've ever seen a self-defense claim where the defendant did not take the stand. I
Right.
can't recall it because by definition, if you claim self-defense, you've got to show that you were in reasonable fear of your life. How
Yes.
do you show that? You show that by taking the stand
Yeah.
and saying, I was scared for my life. Now, they try to have it both ways. They didn't want Carmelo Anthony to take the stand. So they tried to get the evidence in through his friends, through other people. And his friends were not great witnesses. One of them, in fact, said the opposite. And so it was a train wreck, the whole thing.
Yeah, no, it really was a train wreck. And a lot of folks asked also why there weren't character witnesses. Why did they not call people? Why did the defense not put up character witnesses for Carmelo Anthony? And I mean, in my opinion, I would have definitely wanted him to testify. I would have definitely wanted to see those character witnesses. And you're allowed, that was a question, are you allowed under Texas law? You're allowed to call character witnesses. It doesn't happen often because it makes defense lawyers very nervous to do that because of a concept called opening the door. And I want to walk through to our viewers what that means, because I think that's what happened in this case. So essentially, if your client is squeaky clean, doesn't have any wrongdoing in their past, no prior arrests, no prior acts of violence, stuff like that, you can call witnesses, character witnesses, to testify as to their general character in the community. You can't call witnesses to testify about specific good acts. So you can't say, oh, Johnny helped me at church and Johnny bought my groceries for me. Can't do that. But you can have someone say, well, I know Johnny. I've known Johnny for 20 years, and I know he's a truthful person. I know he's a good person. You can testify about that. So that's general. Well, what happens though is you have to make a decision, because if you put that up, you are opening the door to any bad character. And it makes defense lawyers very, very nervous, because there could be things hidden in the deep, dark pasts of our clients that make us very nervous. Now, I'll tell you, for a 17-year-old, I would have been a lot less nervous, because how much life has he lived? How much could he have in his past? But I thought, when I heard that he didn't take the stand, I thought there's something, there's some reason. And so I combed the record, and I found in one of the bond hearing transcripts, his father testified that he had never been arrested before, but he testified, and I think this is so significant, that he had a prior altercation at school, and that was the only time he had been in trouble before. And immediately, I don't know what that prior altercation is, but immediately I knew that's why he didn't take the stand, because that would have come in. And think about, Dave, if you were a prosecutor, what would you have done if you had a prior act of, something, we don't know what, a prior act at school? And I have the exact language of what he testified to. He said, an altercation that school year. Altercation.
Well, okay. All right. Well, no matter what it is, Ashley, I think though, if you are going to say self-defense, you have to take the stand, even if something's going to come out against you, right? Yeah, you just have to, because how else will the jury put themselves in your shoes that you're in reasonable fear of your life? The only other way I could see it is if there was a clear video that showed that you obviously were in fear of your life, that someone's coming after you. Then you may not need to take the stand. But here, there was no video. You had to do it. And I thought that just sealed his fate when he did not.
No, it did. That sealed his fate, and then not having character witnesses to testify about him, that definitely sealed his fate. But I think a lot of folks are curious, and I was curious, why? Because we all assumed he was going to take the stand. We all expected to hear character witnesses. We expected to hear from people, and there was a big void. And so I think it's reasonable that they were worried about that altercation coming in. And the fact that he used the word altercation at school tells me he got in a fight at school, because an altercation, that's, I'm not saying it's a physical fight. I'm not saying it was a knife fight, but it's it's an altercation. That doesn't mean you brought in, that you got busted for bringing in a vape, an altercation is between two people. And so I think that they were worried about the jury hearing that if he did take the stand. And, that's a significant issue. I think we've got a SOT from the actual hearing, from the actual court, if we could go ahead and play that SOT 1.
The verdict, guilty of that top charge of murder. And as you just stated, 5 to 99 years behind bars. We were sitting in there. We were waiting for that verdict to come in. We reconvened once they let us know it was happening. We sat in there, waited for those parties to come back in, and then that verdict was read. And of course, we know the jury had the option of manslaughter if they chose that, but they did not. Clearly, they did not see this as self-defense. They thought this was murder. They thought he went in there, in the altercation, there was intention behind what he did, because they really outlined the definition of murder before the jury went back to deliberate, that it was the deliberate, the intentional cause of harm or death by another person. So that's the way the jury saw it. And of course, Ted, the reaction in the courtroom, there was tears on both sides, obviously for two different reasons. The Metcalf side feels that there's been, vindication for their son's death. There's been justice served. But on the Karmelo side, of course, now Karmelo's going to jail for a very long time. We'll be seeing his family through plexiglass for a very long time.
It's heartbreaking.
Time for some life talk. You probably have life insurance, but you might be paying too much for too little coverage. And did you know if you get it through your employer and then you're laid off, that you could lose your coverage? It's scary to think about, but it's simple to fix thanks to SelectQuote. For over 40 years, SelectQuote has been one of the most trusted insurance brokers out there, helping more than 2 million Americans secure over $700 billion in coverage. Unlike one-size-fits-all life insurance companies, SelectQuote's licensed agents work for you for free. In as little as 15 minutes, they will compare policies from top-rated carriers to find the best fit for your health and budget. Head to SelectQuote.com and a licensed agent will find the right policy for you. Get the right life insurance for you for less and save more than 50% at SelectQuote.com/Megyn. Save more than 50% on term life insurance at SelectQuote.com/Megyn today to get started.
Dave, I want to turn to Pino. So that's down in your neck of the woods. Can you catch us up to what's going on in that case?
Well, this is a big case. Now, first, kudos to our intrepid producers here, Michelle, Natasha. They're amazing, because I asked them about this case and they had it ready. I mean, they did the research, and because I think this is a big deal, not just in South Florida, but nationally to talk about. So George Pino is a big time player. He's a developer in Miami and very well connected. And he got into a boating accident. He was initially just charged with some misdemeanors. And there was such an outcry that they went back, prosecutors, and they looked at it again, and now they've charged him with vessel homicide and manslaughter. And these are both second-degree felonies. Both can carry a sentence of up to 15 years in prison. And this stems from a 2022 boat crash that killed Pino's daughter's friend, a 17-year-old girl, say her name, Lucy Fernandez. And it left another friend of hers, Katie Puig, who's now 21 with long-term physical and neurological disabilities. The whole thing's so tragic, but it blew up because Pino is so prominent in real estate, and also the students involved. They go to a well-known Catholic private school in the area. So this whole thing was just misdemeanors until the Miami Herald published a series of articles exposing flaws in the investigation by the Fish and Wildlife Commission, which handles boat crashes. And after the misdemeanor charges were recommended, there was such a public outcry that the state attorney's office revisited the case, and now here we have it. And so it's already started off in an unusual way. Now, when this trial started, you had opening arguments. And the reason why Pino is being charged is because it wasn't just allegedly a pure accident, that apparently he was reckless, that there was lots of alcohol involved, that he had negligence that led to the crash. In fact, let's hear the prosecutor sought to describe why Pino's on trial here.
There's no evidence to conclusively prove that George Pino was drunk. He's not charged with boating under the influence causing a death. There's no evidence that he deliberately crashed his boat. into that channel marker. If the evidence supported that, he wouldn't be charged with manslaughter and vessel homicide. He'd be charged with murder. But the evidence does support a finding. The evidence in this case will show conclusively this was not just an accident. This was a bunch of factors that, when they all come together, form the inescapable conclusion that George Pino was reckless and he was culpably negligent, and as a result, Lucy's gone. And that's why at the end of this trial, I will ask you to return a verdict of guilty.
Also, there's a video of him where he's breaking down. And that was something that had to stop the trial. He was like breaking down in front of everyone. Can we show that? We can talk over it as you show this video.
I'm curious in this video, Dave, it looks like, and it's been reported that maybe next to him is one of his daughters. Is that traditional in Florida?
Not that I'm used to. And
Yeah.
that woman next to him is reportedly one of his daughters. And it's not like when in our courtrooms here in Palm Beach County, we're not used to the family sitting at the defense table unless she's a paralegal there or something. I don't understand. The judge allowed Pino to step out and remove the jury, and it's awful. So if you want to know what happened here, Pino and his wife, they took their daughter, who was celebrating her 18th birthday, and 11 of their friends to a sandbar in Biscayne Bay back in September 2022. They were going over to the Ocean Reef Club, very nice place, a private club for dinner. And Pino allegedly, was driving just under 50 miles an hour on the boating on the wrong side of the channel before he slammed into a bright green channel marker. It's sending Pino and all 13 of his passengers into the water. And poor Lucy was critically injured during the collision and died in the hospital. And the prosecutors are alleging that he drank alcohol, provided alcohol to his daughter's underage friends, and then sped, and he didn't wear a kill switch, and he was driving over 20 miles per hour faster than he was earlier in the day and was drinking. And then here's the craziest part. He admitted to consuming 2 beers, but 61 empty and partially empty bottles and cans of alcoholic beverages were found on his salvage boat after the wreck. Fortunately for him, he has a really good defense lawyer, Howard Shrebnick. Fun fact, Ashley, Howard Shrebnick, one of the top criminal defense lawyers in all of Florida. His partner in the past, I don't know if he still works with his brother, his younger brother, was my summer camp counselor when I was a kid. There you go.
Oh my God, that's full circle. Well, I see why Mr. Pino was crying. Does not look good for him.
Yeah.
But we will keep you posted on this. But next up, we're really excited to welcome Cody Thomas of Court TV. And he was actually in the courtroom and on the ground for the Carmelo Anthony case. He is going to discuss that with us, who is, as we all know, as we've been discussing, is the high school athlete from Texas who was just convicted of stabbing a fellow classmate, 17-year-old Austin Metcalf, to death last year. Stay tuned.
Starting something new, especially a business, is hard. So much work goes into this thing that you're not entirely sure will work out. And it can be hard to make that leap of faith. It helps, though, when you have a partner like Shopify on your side. Shopify is the commerce platform behind millions of businesses all around the world and 10% of all e-commerce in the United States. With hundreds of templates, Shopify helps you build a beautiful online store that matches your brand style. It's packed with great AI tools that write product descriptions, page headlines, and even enhance your product images. Their marketing tools also help you create email and social media campaigns wherever your customers are scrolling. That's really helpful. Plus, Shopify provides world-class expertise in everything from managing inventory to international shipping to processing returns, all with 24/7 award-winning support. Sign up for your $1 per month trial today at shopify.com/MKTC. Go to shopify.com/MKTC. That's shopify.com/MKTC.
Welcome back to the MK True Crime Show. Joining us now is Cody Thomas. He's a field reporter for Court TV, and he's the host of On the Record. So excited. Cody, you have been inside the courtroom this entire time covering the Carmelo Anthony trial that we have all not been able to watch, which is killing us. No audio, no video allowed. and you're one of the few that actually was in there. So we have so many questions for you, but can you just tell us the overall feel of the trial? I mean, it had to be heavy. Like this is two young lives that are ruined. It's just heartbreaking.
Yeah, actually, it was one of the most emotionally heavy trials that I've covered in my 3.5 years at Court TV because you have emotions on two sides of the spectrum, right? You have this one family who's lost their child and loved one forever, and then you have this other family whose son and loved one's liberty was at stake for 4 days, as this trial went on. But I will tell you, as emotionally heavy as this trial was, it was really full throttle and pedal to the metal. The judge was wasting no time. It was prompt. I mean, we had Thursday was the beginning of, official testimony. Thursday, Friday, we had a Saturday session and then a little bit of Monday before both sides rested. But it was 9 hours a day inside that courtroom with one 40-minute lunch break and then one, maybe two 10-minute breaks in the afternoon just to go to the bathroom and everything for people in the gallery. So the judge is really moving this thing along. And, the prosecution called 21 witnesses, the defense called 6 witnesses. A lot of those eyewitnesses were students, of course, who were under the tent at that track meet. And you were hearing all sorts of, you know, different but very similar accounts of what happened that day that all had the common denominator that Carmelo Anthony was the instigator and he was the aggressor. So you're hearing all this different stuff and you're seeing body cam footage and you're hearing 911 calls, just a very grave situation, a grave trial, and again, emotionally heavy story to listen to while we were in that courtroom.
Yeah, I mean, extremely emotionally heavy. To one life lost and one about to be lost, or luckily not lost forever, but definitely freedom taken. I'm curious, as a defense lawyer, when I watch these cases, I love to see how the judge is and how the feel is. Are they? You can tell. I mean, they're ruling against the defense,
Hmm.
they're ruling against the state. You can tell if there's a bias at all. I mean, did this
Hmm.
judge? Seemed very, militant on how fast he was moving. But how did he seem unbiased? Did he seem to treat both sides the same?
He absolutely did. Surprisingly enough, he was laying down the law in that courtroom. There was a lot of rules that he had. Of course, the no cameras and no audio being recorded. You couldn't wear any sort of clothing that had any sort of signage leaning one way or the other. And each the defense attorney and the prosecutor, if they were going over time in their opening statement or closing argument, he was making sure that hey, you got 2 minutes left. You've been running or approach or whatever he had to say to wrangle the courtroom the way he
Yeah.
wanted to. But I didn't sense any bias on his behalf at all, which was, interesting because, in a lot of cases we cover here at Court TV, you can kind of tell by the attitude of the judge sometimes which way they're kind of leaning. But this one was kind of down the middle to me, Ashley.
That's why I was curious because we can see that when we're watching the trial. I mean, you can definitely tell. And,
Yeah.
sometimes it's not real bias. Sometimes, one side kind of deserves it more than the other. But it seemed
Hmm.
like this was a judge that was really, really fair. He did run a tight ship, though. I saw that he had time limits on everyone, which, personally, I'm like, hey, that's fine. As long as you're an equal opportunity a-hole, is kind of how I call it. If you're going to control one side, at least control the other side the same way, Like, I'm fine with that as a
Yeah, yeah,
lawyer.
yeah, yeah.
Uh,
Absolutely.
so,
And
so
then,
tell us.
oh, go
Yeah.
ahead, go ahead.
No, no, no. Finish, please.
Well, to the topic of the tight ship, the day that the defense rested, that would have been 2 days ago on Monday, right? And again, we talk about these 40-minute lunch breaks, and there was a lunch break we had on Monday, and when we came back, he told us to be back right at 12:30. Not really to be back at 12:30, butts in seats at 12:30 inside the courtroom so we can get started, right? And so we get back outside of that courtroom, 12:20ish. Everyone's getting there early. And it was odd because he's been such a stickler about all being prompt, and then so we get back and it's 12:45, then it's 1 p.m. and we're looking around like this is abnormal, right? Long story
Mm.
short, an hour and 45 minutes go by with no explanation as to why we're all still sitting out there. So of course all this speculation starts coming in. Are they brokering a last minute plea deal? Are they prepping Carmelo
Oh,
Anthony to
yeah.
testify? But then we end up going back inside, and then the defense just kind of abruptly rests. It's kind of surprising after only 6 witnesses. Some of the witnesses were considered a little lackluster. I don't know what, where they were going with their narrative, but they rested very, just out of nowhere. But again, that hour and 45 minutes, I should have told us something when we were sitting there that something imminent was on the horizon when we were sitting outside that courtroom on Monday.
Ooh. So you all were not allowed in during that conference, whatever they were
No,
talking about.
no. The
Interesting.
only
And there's
people
been
I
no
saw that walk
rumors
in was
about it.
Carmelo Anthony's. The only people I saw were Carmelo Anthony's parents going inside. So there was no
Interesting.
circulation about what was, going on in there during that time.
Yeah. Well,
Yeah.
they have to go over your right to testify, because that's one of the things that the lawyer can't control. That's one of the things that the defendant has an absolute right to choose if they testify or not. So the judge always has to go over a colloquy, but that's a little long for that colloquy. It's usually maybe 10 minutes. So I'm wondering if they had some other things they were fighting over. That would be very interesting to I have my guess, but that would be very
What's your
interesting.
guess? What's your guess?
As I
My
say, what
guess,
is
and this
it?
is what I've thought. Yeah, so I've thought this all along because this is something, I love my clients to testify. So this is something I agonize over in every single case. What is going to bite me in the butt if my client testifies? And there was a prior altercation that Carmelo Anthony had had at school. It was not a criminal arrest, but a prior altercation can actually come in if you testify and open the door to character. So my guess is they were going back and forth because I guarantee that lawyer did not want to put him on the stand if there was a risk that that might come out. And so they were probably arguing back and forth whether or not they were going to be able to go into that. And quite frankly, whether or not his witnesses had opened the door, because I think those lackluster witnesses were lackluster because they were terrified to open the door to whatever that altercation was. And I get that because I've been there. This, when you hear the words "you open the door," you literally just want to vomit as a defense lawyer because it's the absolute worst thing ever. So I'm guessing it had something to do with that.
What do you think,
This
Cody?
is why you're the expert. I mean, that sounds just because I'm just a TV boy. I had this report
Well,
without
that's why they
hearing there.
kept
So
you
that
out.
sounds. Yeah, I mean, yeah, all of us are sitting there with no explanation, and the thing that we were thinking about was the plea deal situation. We're like, oh, because you got to think about the facts of this case. Are the facts, right? It's an uphill battle from the beginning, and they never really, which to my surprise, they never addressed the defense why he had a knife in the first place on school grounds. They had this officer that was
Mhm.
on the stand for maybe 12 minutes, 10 or 12 minutes,
Yeah.
and the only thing that got out of him to me that was of note was that in Texas it's not illegal for a 17-year-old kid to carry a knife with a blade that's less than 5.5 inches because his blade was 3.5. He said it was not, criminally illegal. Of course, it was against some school policy, but not illegal in the eyes of the law. And that's pretty much all they got out of it. But you still have to explain why this teenager, I feel, had a knife in his book bag at a track meet. Because during the entire prosecution's case, when they had all those eyewitness students who were under the tent, all of them testified and said, we've never heard of a knife at a track meet, let alone somebody sitting here ready to use it. So they never
Yeah.
went into that. No one ever threw out a reasoning as if, maybe he loved to camp. Maybe they cut nylon when they're setting the tent up. They didn't address any of it. So that was surprising to
He
me.
forgot it. Yeah, no,
Forgot it. Anything.
that was surprising. That was really surprising to me too, because I have a daughter who ran track, and I was
Mhm.
actually, this case made me think back about all the memos we get every time she would have a track meet. You get like this printout that says what you're allowed to bring, what you're not allowed to bring. Some campuses are, you have to have that clear bag thing. Some don't. It's going to be hot. Bring a water bottle. They always
Mhm.
said, don't bring valuables and don't bring weapons, like literally in bold on every single flyer. It reminded the parents, and the kids, you can't bring that. And so I just was thinking back to that, and I was like, she carried a track bag. I mean, it's got biofreeze in it. It's got like blister cream. It doesn't have a weapon. Like that's like, how did that get in there? And I wanted to hear that. I wanted that explanation. And I think the jury probably wanted it.
That's what I was gonna say. I'm sure the jury wanted to hear that as well. Why this was here. And I ran track as well in high school, Ashley, and also my mother was a middle school principal, so I had all the knowledge of the school rules. Generally speaking, of course, I grew up in Georgia, and this is in Texas, but weapons on school grounds are prohibited. I feel nationwide. I mean, you don't hear about just guns walking in school just because it's a lawful carry state. You can't really do that. You know what I mean?
Right.
So again, to your point, I'm sure the jury wanted to hear that, and that's something they just never got. Even if it was, just the narrative that the defense was trying to paint, they threw no option out there for them to even consider as to why this was even there.
Yeah.
Cody, what do you think overall of the defense? I mean, we've been critical of them because they didn't call their client to the stand and they didn't seem prepared on some of their witnesses. One of their witnesses backfired on them. Do you think they did an okay job, or you think there's an ineffective assistance of counsel claim coming?
I would not be surprised if that claim was coming, Dave. That's kind of the sentiment that we got, as media, just this the aura we got of that. They only called these 6 witnesses, and to your point, Dave, I believe you're talking about that witness they called where it was surprising to me. Again, I'm no lawyer. I don't have any expertise on strategy when it comes to litigation, but he calls a witness, this student, and the first thing he says is, so we've never talked before, have we? The student's like, no, sir. And he's like, other than the 2 minutes out here in this hallway before you got on the stand. Yes, sir, that's correct. And I'm just thinking, witness preparation, that's not a secret. We know that's a real thing. And so, he's
Right.
asking them questions. He's trying to, paint this narrative, and this kid's just kind of negating just things that he's trying to say. And then the kicker to me was that under cross-examination, the prosecutor gets up there and is like, so you and I have talked longer than 2 minutes, haven't we?
Oh my
Yes, sir. I've texted your father even last night. This was a Saturday witness, so this would have been the Friday night. I was texting your father last night. Yes, sir. And I'm just sitting there thinking, why is the prosecution having a better relationship with a defense witness? That, I mean, just
Yeah.
the simple fact of that didn't make any sense to me. And
Makes
and
no sense.
again, a defense witness, you guys, defense, I gotta implore it. This kid said that Carmelo Anthony was the aggressor. Why would you call a witness, I guess, that you never
Right.
talked to? And
Because
then at
he'd
the end
only
of the
talked
day-
to him for 2 minutes.
well, I mean, yeah. And then again, backfired against you. Like I don't know. That was a shock to me. That was what I took away from the defense's case out of these 6 witnesses.
So, like, you're in the courtroom. I mean, did they have an investigator that you could see? I mean, I'm just curious because normally, we see the defense table and there's like all these assistants and stuff. And we saw how much
Mhm.
money was raised. And I certainly don't want to, be judgy about what they spend their money on. But like, I'm not going to try a murder case without my investigator. No way, and
Yeah.
I'm not going to be calling witnesses that I don't know what they're going to say because my investigator is going to have recorded their statements ahead of time and I'm going to have it locked down exactly what they're going to say. So, like, did you see
Mhm.
any of that?
I was gonna say, if there's an investigator, if he was sitting there, I didn't see him, and they didn't call him. They didn't say anything, of that nature. And again,
Yeah.
their case ended and it rested so abruptly. Like we were expecting more because I remember sitting back there in the row of media. There was only 8 of us in there, and when we came back in after that long break that we had no explanation for, we sit down with our laptops ready to go, and then the defense rests, Your Honor, and we all just kind of okay, that's it, and then the state
sure that's
rested,
what
no
the jury
rebuttal, so
felt.
that was it.
Yeah,
Yeah.
right. Yeah. What about the claims that the judge or prosecutor erred in the jury selection where they were intentionally trying to target black jurors? Do you think that there's anything nefarious going on, or do you think that the answers you heard gave legitimacy to striking them?
So of course, when that was, I was there for the 3rd day of jury selection when this was going down. Of course, I was running in and out of the courtroom because we were allowed to float during that day. I was doing television and running back in. But the issue was it came down to these 3 black women, right? That they wanted to strike, and the defense claimed they were striking them on, racial bias, but then the prosecution said they were striking them based on occupational bias because all 3 of them were teachers, and this happened at a school, and that was where they went with that. And then of course the judge granted them to be stricken. How that went. So those are the only 3 black jurors that were, I guess, possible towards the end. But there were 3 Asian women and then 2 other Middle Eastern, East Indian looking women that were on the jury as well. So of course it was a majority white jury, but there was a sprinkle of diversity in there. But of course, that big headline with the optics of this being, black kid, white kid, heinous crime, no black people on the
Yeah.
jury. Is this really a jury of his peers? Which I guess I can see, the sides where that's coming from, but I didn't sense anything nefarious as far as, targeting that, like, let's make sure let's not have any African Americans on the jury. I didn't sense that, but of course I don't know what was going down, back in the room when they were making those final selections.
So the state wanted to strike them because they were teachers, not the defense,
Yes.
right?
Not
Interesting.
yes, correct.
Because I was wondering, I was
Mhm.
like, well, I would be nervous to have a teacher on if I was the defense. That would make me nervous. So that would have been an interesting call on their part. But the
Mhm.
state, that's kind of surprising. When in the pool, whenever were you able to see like when the jurors actually came in, the full panel? I mean, I'm sure there were a couple hundreds. I mean, what did they have some diversity in the panel as
So
far
we
as you
weren't
could see?
able to. We
Ah,
had, and where we were sitting, there was a screen. Like we were in the courtroom where the trial was going to take place, and then there was a screen, so we saw the prosecutor and the defense attorney, but we did not see the faces of the jury. We heard them speaking when they were asking questions, and a lot of the issues that were raised in the hours there was, some of these jurors were parents. Then they
yeah.
obviously there was more black jurors in the entire pool. It was 600 people they pulled together for this, and then by the time I got there on Wednesday, that whittled it down to 250, and then they had that to choose from as they were going. But a lot of the issues that were being presented was that they couldn't see themselves sending this young man away for the rest of his life, only being 19 years old. That was a
Yeah.
commonality, them being parents. A lot of them said, maybe 5 or 10 years, as the defense was asking questions, the prosecution was asking questions, trying to weed out the ones they didn't want, of course. And the defense and the prosecution had 10 strikes each make the strikes when they got down to that selection. But that was a common issue that was coming up. They couldn't put this kid away for a long time or forever. Regardless of, you got a kid over here that's gone forever. That was one of the things in their closing argument, the prosecution's case. They were, well, before the sentencing, just after the guilt phase, before the sentencing phase, when they did those last minute closing arguments, the prosecutor was pretty much saying, "Hey, I'm not telling you what to do, but you could send a message with your choice here." Community was a common word. He was, holding people accountable in the community. And he said, if you're considering a life sentence, think about the Metcalf family. Then, he had a big bellowing voice, and he was like, Jeff Metcalf, Megyn Metcalf, Hunter Metcalf have all been sentenced to life sentences, a life sentence of a void in their hearts in their home. And I thought that was very powerful, of course. And I'm sure the jury took that into consideration once they went back in there and started deliberating that sentence that ultimately ended up being 35 years.
But why didn't they put on the Metcalfs onto the stand to reach the jury that way instead of just arguing about it?
That was what we thought, that Hunter Metcalf was going to take the stand. He wasn't there the entire trial, the twin brother, who was also under the tent that day. And so, we're sitting around thinking he's not in here in the gallery, which, testifying witnesses aren't allowed in the gallery. So we thought the prosecution was going to end with a bang. They started off with their forensic video analyst, then they went down to the head track coach at Memorial. Then they had a slew of children, a slew of eyewitnesses, students from all different assortments that saw what they saw. And on the topic of them, their stories all pretty much corroborated. The way I've described it as, it's like a tree, the same trunk, but just different branches. Some students may have said it was a one-handed push. Some students may have said it was a two-handed push, a little more aggressive than whatever. But the commonality is that, Austin did, initiate the physical contact, but it wasn't anything they were scared of. They thought it was just two boys mouthing off. Because, we've all been in competitive sports. Dave, you and I have been young men before. You know how boys can get when all the hormones get to running and you got friends around and, all that.
Oh, yeah.
You get the trash talking, but they thought that was
And
it. They
your
weren't-
rivals. I mean, your rivals.
Yeah.
I was thinking about it. I was like, we chant for our teams. We have like weird sayings and phrases, and we dress ourselves, we body paint ourselves in our team
Yeah.
colors. Like there's an immense amount of rivalry, and for this kid to go in the other essentially locker room, it just seemed like a bad idea. Seemed like a really bad idea.
And actually, that's a good point, the locker room thing, because a huge part of the prosecution's case was this phrase they called tent culture, which you had a daughter that ran track, I ran track, those tents, so that's where the teams are. And while track is,
You
social, like,
change
walk around in
clothes
lanes.
in those tents.
Right. And that's the point they made. Locker room, it's like if you're in the NFL, if the Colts are playing the Texans or something, they're not going to go hang out into the locker room just because the running backs know each other. They'll hang out afterwards, but not during the competition. So that was the point that the prosecution was trying to hammer on, to which, the defense was challenging. And you and I know this well, Ashley, that, track meets are a little more social than other sporting events. That you can walk by, what's up, dude, if you know him from the rival school. Right. But the prosecution was saying, you wouldn't go into there and hang for 20 or 30 minutes. So that was a big contentious part of this whole storyline.
Why do you think, Cody, he was there? Why did he go on that tent? There were all these tents there. Why did he choose that tent?
So the whole narrative, the defense's narrative, was that rain was a big part of this storyline. They said it was raining that morning, and they talked about Texas weather, how the rain could be coming down, it could be misting, it can come down again in 5 minutes. And the story they were painting was that Centennial, for some reason, was the only school that did not have a tent that day. For some reason or another, they didn't have a tent. You could get under the bleachers. That was also an option. That was what the prosecution was bringing up. But the defense was trying to say he was in these bleachers. It was starting to rain, and we heard about this character, this student named Eddie, this Eddie kid that we heard about in opening statements. The defense said, "Oh, Karmelo and Eddie knew each other. He was under the Memorial tent. That's why Karmelo walked over there, because Eddie was childhood friends from a young age, 5 or 6 years old, with Karmelo's ex-girlfriend, some girl who was dating at the time. So that was the link they were trying to make with Eddie, right? And so Eddie takes the stand for the prosecution, which surprised me, because I'm like, if the defense is talking about Eddie, I thought Eddie was going to be a defense witness. And so Eddie gets up there under direct examination with the prosecution, all but says, I knew Karmelo. Karmelo was, we were cool and all, but I wouldn't say we were like friends. And I was like, what? We've heard about this Eddie guy. And then, which the defense pushed back on. The defense did push back, and they brought up 8 or 9 pictures of Karmelo and Eddie in these pictures together, these, group settings at Eddie's house. I think there was 2 or 3 pictures of just them two. But I guess, the narrative that I feel like the jury went with is that if Carmelo's dating this girl whose family and Eddie's family are really tight because they've known each other forever, if he's dating her, then by default he's going to be at these family gatherings at Eddie's house because the majority of the pictures were group settings, right?
Yeah.
And he's going to be cordial. He's not going to go to these houses and these grandmother's birthday parties and be acting a fool or anything. So that's where I feel like the jury went as far as the picture pushback. But to your question, or to your point, I guess it's up in the air as to why he was under that tent because some people say he went under there the whole to instigate purposefully. Of course, the jury came back with murder, so they decided on premeditation, whether that was 10 minutes of premeditation or 2 minutes of premeditation with the hand in the bag, the touch me and see what happens. I guess they could take that as even though it was only 5 seconds, you had your hand on a blade and you thought about doing it. So that's
all
where
it takes. It's all it takes. Yeah.
Mhm.
Ugh, such a tragedy. So you were also outside. I want to, before we lose you, I want to talk about what the scene was like outside. I know we've got SOT 4, if we can play that. And then if you just can sort of explain how it felt walking in and out with all of these protesters. If we could play SOT 4.
That's it. Yeah. Some room, guys. They in the midst. Yeah. It ain't the end of the road, though. That's his uncle and his aunt.
I love you. So that's Carmelo's mom, right?
Mm-hmm.
Yeah, you were gonna say something.
And I mean that is a testament to what that outside looks like. And I am just, I got some pushback thrown at me when I was out there for a couple of days, calling me all sorts of names. Just and I'm reporting what's being heard in the courtroom. I'm sorry if you don't like what's being reported. They were just
Right.
coming at me. They were coming at everybody. But this is just what I'm hearing. The guilt phase hadn't happened yet. I'm just telling you what each side is saying. But it was definitely very tense. But I'm thankful that yesterday on verdict day, that was obviously the tensest day, right? They had, they upped the ante on the security. You got all these, big sheriff's deputies with the cowboy hats on, looking like they're really out of a Texas Ranger movie out there, just trying to
Oh
keep
my
the
God.
peace. I'm serious. They had the boots on. I'm
I
familiar.
know. I know.
They're the real deal.
Yeah, they are. But there was a lot of profanity thrown around between each side supporters and all. I mean, you had advocates from either side, radicals from either side as well, not just community members. But you saw a lot of verbal confrontations with people in each other's faces this close, and everyone had a selfie stick with the phone on it, because everyone's an independent journalist these days, and everyone has a platform and all that different stuff. But luckily, no one got hurt. There were no more, physical altercations, but verbal altercations, yeah, that was pretty rampant. Just what you saw there, that's a testament to what was going on out there.
Well, verbal disagreement is very American, but using a knife to stab someone is not. And that's the tragedy in all this, especially when you're 17 years old. It just didn't have to happen, didn't have to escalate like this. I do think the jury made the right verdict. I just, I wish that the jury was more diverse so that the community would buy into it more. It does seem like this is going to be a real sticking, like a sore point for many years to
Mhm.
come. And that's a shame. But your analysis is so insightful because we didn't get access to any of this because the judge didn't allow it. Now, just as a final question here, what's your take overall on cameras in the courtroom? I know you're a member of the media, so you probably say yes, but I mean, I don't see any reason why federal courts, state courts should ever ban cameras in the courtroom. We need more transparency during this time of rapid conspiracy theories, not less.
That is my exact sentiment, Dave. I think public transparency for things like this, especially something with as much just emotional connection, and polarization that you see. Again, the optics, black kid, white kid. I think transparency is extraordinarily important in these because I'll tell you, sitting in there, there of course there's all the racial bias claims and like that against the Metcalf family. I'm sitting in there, a majority of those student eyewitnesses were either black or Hispanic. Of course, you had 6 or 7 white
Wow.
kids get up there too, but there was a lot of diversity on that stand. And I'll tell you, is Saturday and Monday, and on verdict day, actually, Saturday, Monday, and verdict day, yesterday, there were 5 boys and 1 girl that came in, and 2 of the boys were black kids and went straight to the Metcalf family. And I'm talking like the mom wrapped them up gave him kisses on the cheek, shook the dad's hand really solid.
Oh, wow.
When they're showing some of that body cam stuff, these kids are crying. They look like former teammates. They look like these big
Yes,
old boys,
yes.
whether they're seniors or college kids or whatever they are. But there was diversity within that courtroom, and I just wish, on the outside, of course, no one knows that, and it's a weird topic to try to bring up when you're talking about somebody getting stabbed. But there was a lot of diversity going on there on the stand and within the gallery, and the public wouldn't know that. We can come in
No,
here
the
and say it all
community
we want,
needs
but
to know that.
yeah,
Yeah,
exactly.
exactly.
So I
Because the
sitting
communities
here
are,
behind them. Yeah, that's what I'm saying. And then
yeah.
I didn't pick up on any racial bias inside that courtroom. Again, I don't know these two families from second base, but within that courtroom, within that trial setting, I didn't pick up on any of that.
Well, that's why it's so important you were there and you're telling what happened because the world couldn't see. And it does when we saw the jury makeup, we were worried about it. And, you hear reports and you don't know what's the truth. And knowing though what your experience was is just, it's incredible. It's invaluable. Thank you so much for sharing it with us. We really appreciate it. I hope you have a safe trip home and thank you for joining us.
Absolutely.
How do our
Thanks for
viewers
having me. Happy
find
to do
you?
it.
Yeah. Tell everybody how they find you. What's your show and your handle?
Yeah, I'm a court TV anchor. You can watch me every night from 4 p.m. to 7 p.m. on the desk, unless I'm out in the field like this. Facebook and Instagram is kind of my bread and butter. On Instagram, I'm Cody Thomas
Awesome.
_ Facebook is me, and you'll see me sitting there on a little stool looking nice and dandy in my suit and everything. But yeah, you can find me, just search my name. I'm on pretty much everything.
That's awesome. We love it. Well, thank you so much. It was great having you.
Cody, thanks for being with
Happy
us.
to do it. Happy to do it. Thanks for having me.
And now for our closing statements next. You don't want to miss it. We'll be right back.
I love when I find something that tackles the root of a problem rather than just slapping a Band-Aid on it. This podcast is sponsored by Veracity, and they are revolutionizing health by focusing on the core of our energy and weight, metabolism. Veracity offers drug-free, doctor-formulated solutions like Metabolism Ignite. It's the #1 doctor-recommended GLP-1 booster and alternative, designed for those who want results without the side effects or allergens. Founder Allie Egan, a certified hormonal health coach, created Veracity after her own metabolic struggles. The formula is a clean blend of lemon verbena, hibiscus, green coffee bean, and magnesium. It's 100% natural, caffeine-free, and safe to use even if you're already on GLP-1 medications. Best part, no negative side effects reported in clinical trials. So it's no wonder that this has sold out 10 times. So before Metabolism Ignite sells out again, make sure the switch to GLP-1s the natural way. Head to veracityhealth.co and use code MK for up to 65% off your order. Once again, that's veracityhealth.co for up to 65% off, and make sure you use my promo code MK so that they know we sent you. Welcome back to MK True Crime. Now it's time for our closing arguments. People keep asking how the system failed Carmelo Anthony, and I'll tell you what I see after 25 years as a criminal defense lawyer and a former public defender. I don't necessarily think that the system put that knife in his bag. The system didn't make the decision to walk up to a rival's tent during a heated rivalry match. The system didn't make him stay in a confrontation that he could have easily walked away from. Every athlete knows the rules. They get them. The parents know the rules. No weapons. Respect boundaries. If there's trouble, walk away. Leave. Those are not complicated concepts. The uncomfortable truth in this case is that bad outcomes, are often the result of bad decisions. One bad decision leads to another, and that's what ends up with two boys on this collision course that ended in tragedy for both families. When it was over, instead of hearing, I made a terrible mistake, I'm sorry, I wish I could take it back, all we heard was blame. Blame the victim, blame the system, blame races, blame society, blame the jury, blame the judge, blame everybody. But what we never heard was accountability. Never heard personal accountability. And that's the part that really matters, because the law isn't just about punishment. It's mostly about deterrence. It's mostly about us wanting the next teenager standing in the same exact moment that Carmelo Anthony was standing in to choose differently, to choose to walk away, to choose to cool off, to choose to go home alive, go home to his family. We don't honor Austin Metcalf's death by pretending that this was justified. We honor it by teaching the next kid that choices have consequences, and that one terrible decision can change everyone's lives forever. Thank you for joining us.
That was really well said, Ashley. Thank you. And for my closing statement, I want to return to the Karen Reed case because I got a lot of messages after my last closing statement, including one from a friend of mine, Lissa. Lissa, thank you for reaching out. And Lissa is a Karen Reed fan who had all these reasons why she was not guilty. She gave me boom, 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 all these points, and I want to debunk them because that's what I do here. I debunk conspiracy theories and I stick to facts. So her question was, how do you explain the Emmy finding his head injury, John O'Keefe's head injury, not consistent with a car strike, or the bites on his arm, or his body temperature, or his iPhone step tracker, or the missing 30 minutes of video when her car, Karen Reed's car, was in the Sally portfolio? That was the text message he sent. Okay, let me respond. I'm going to do this as fast as I can. Number one, the medical examiner's findings on the head injury. Supposedly, the medical examiner found that John O'Keefe's injuries were entirely inconsistent with a car strike. That's what the Karen Reed supporters say. Wrong. It's a distortion of how the formal autopsy results were. The ME officially ruled the cause of death as blunt impact injuries to the head and hypothermia. And the prosecution's crash reconstruction experts testified that a high velocity reverse vehicular strike from a heavy SUV perfectly aligns with the blunt force trauma to the head and to the physics of how O'Keefe's body was thrown onto the lawn. Number two, the scratches and bites on his arm. Well, they said that those deep scratches, that was from a dog, not from a car, proving he was attacked inside the house. But the prosecution got the better of that one at trial because there was no canine DNA found whatsoever on John O'Keefe's clothing, on any part of him. No canine DNA. Generally, if you have dog bites, it'd be dog DNA. Also, dog attacks leave these crushing punctures in specific wounding patterns, none of which were present on O'Keefe's arm. They were linear scratches caused by O'Keefe striking the broken sharp fragments of the SUV's taillight and pieces of plastic housing during the impact. Number three, his body temperature. They say that the rate that his body cooled was not consistent with being outside, was consistent with being inside the house where he supposedly was beaten to death and then dumped on the lawn. But digital data from O'Keefe's phone showed a steady, steep drop in internal battery temperatures starting almost immediately after 12:30 a.m., confirming the device and its owner were exposed to the freezing elements early that morning. How about number four, the iPhone step tracker? The Apple Health step tracker supposedly showed O'Keefe walking steps and climbing stairs at a time when the prosecution said he was already dead. Well, that's a misunderstanding of how the mobile data is recorded and parsed. During the trials, the forensic examiners testified that Apple Health does not record steps in exact real time. Instead, it logs data in aggregated chunks and relies on background algorithms that retroactively assign timestamps. So also erratic movements such as being hit by a car can easily be misread by an iPhone's internal system as steps or floors climbed. And lastly, the missing 30 minutes of the Sally Port video. It was Port, not portfolio. Supposedly there was a deleted 30 minutes of video footage. No, it's government. They use the lowest cost alternative. Just ask the Epstein jail. Automated digital security systems in these municipal buildings, they operate on motion activated loops and they have overwrite cycles. And so the gaps are a reflection of these routine system technicalities, not a cover up, especially when the physical evidence is so strong, like the broken taillight pieces found at the scene. Come on. So good people can differ on this. And my friend Lissa is awesome, will remain a good friend. But what continues to amaze me is how quickly Karen Reed supporters are to jump on every conspiracy theory while completely disregarding the most definitive damning facts. Like the fact that the exact data from Karen Reed's Lexus confirms she pulled forward slightly before slamming the SUV into reverse at 74% throttle, gunning the vehicle to over 24 miles an hour for 87 feet until a sudden 0.6 mile per hour speed drop recorded the precise physical moment. that her car struck John O'Keefe. That's data, not conjecture. So you can stick with your dog bite without any dog DNA and claim Karen Reed is innocent. I'll stick with the facts and know that she is not. That's my closing statement. Ashley, it's been
I
a
love how
blast as
passionate
always.
you get about Karen Reed.
You know, just as a former prosecutor, it's like,
I know. Oh,
Absolutely.
I bet. I understand because I get like that with defense cases. But so
Right.
thank you so much, Dave, my co-host, Dave Ehrenberg. And thank you all for joining us. We hope you have a great week.